If you were hit by a truck in Florida, you're probably living in a strange mix of pain and adrenaline. Your car is damaged, your body feels off, your phone won't stop ringing, and everyone keeps asking the same question, are you okay? Here's what I want you to hear right now. After a truck accident, you are not just dealing with recovery, you are dealing with time. In Florida, there are 2 deadlines that can quietly make or break your case. Deadline number 1 can hit in 14 days. Deadline number 2 can hit in 2 years. And while you're trying to heal, the trucking company and the insurance carrier are already moving. They are collecting statements, controlling narratives, and protecting their money. My name is Doug Burnetti. I'm the founder of Burnetti PA, and I've been representing injured Floridians for over 30 years. Today, I'm going to walk you through exactly what a truck accident lawyer does to protect you and why the earlier you act, the stronger your case usually is. Getting you medical care fast because Florida's 14-day rule is real. Let's start with the part that affects your health and your case. In Florida, most people have personal injury protection coverage, also called PIP. Under Florida Statute 627.736, your PIP medical benefits are tied to getting initial services and care within 14 days after the accident. That means if you wait and hope the pain goes away, you are risking your ability to access the PIP benefits that help pay for care. And there's another detail that many people do not learn until it's too late. PIP is up to $10,000, but the full amount is generally tied to whether a qualified provider determines that you had what's called an emergency medical condition. If they say you did not, PIP medical reimbursement can be limited to $2,500. So what do I do as your lawyer right away? I help you get connected with the appropriate medical providers who understand accident injuries and document them correctly, not for drama, but for accuracy. I want your care to be medically appropriate and clearly recorded because vague records are what insurance companies use to argue your injury is not from the crash. Example, I had a client who felt like it was just stiffness. We pushed for early evaluation. Imaging showed a real injury and the paper trail supported the treatment. That is how you prevent insurance companies from turning your pain into a debate, taking over the insurance calls so you don't talk yourself out of a case. Here's the hard truth. After a truck crash, the adjuster calling you is not calling to help you. They're calling to control exposure. They may ask for a recorded statement. They may sound friendly. They may offer a quick check that feels like relief. But early offers ignore the most expensive part of a case, the future. Future treatment, future lost income, future limitations, pain and suffering when the law allows it. And they are listening for sentences they can use later like, I'm okay. I didn't see them. It wasn't that bad. I might have been distracted. Once I'm on the case, I handle communications. That protects you from accidental admissions and from pressure tactics. Also, Florida's fault rules changed in recent years. Florida is now a modified comparative negligence state for most negligence cases. If a party is found to be greater than 50% at fault for their own harm, they may not recover damages. If you are 50% or less at fault, you still recover, but your recovery can be reduced by your share of fault. Insurance companies know this. They look for ways to inflate your percentage. That is why your words matter. Investigating fast because truck evidence can disappear. Truck accidents are not like typical fender benders. A commercial truck can generate valuable evidence, electronic logging data, GPS routes, dispatch records, onboard video, maintenance records, inspection histories, and sometimes event data that captures speed or braking. Here's the problem. Trucking companies often have teams that respond quickly, and some data can be overwritten or lost if nobody demands preservation early. Video systems can loop. Electronic records can be updated. Witnesses can disappear. That's why one of the first things my firm does is launch an investigation with urgency. We send a preservation letter demanding the trucking company keep key evidence. We identify where cameras might exist, including nearby businesses and traffic cameras, and we move quickly before footage is deleted. We gather witness statements while memories are fresh, not months later when everyone's story gets fuzzy. In trucking cases, the story is often not just who hit who, it's what happened 10 minutes before the collision, what the driver was doing, whether they were pressured on a deadline, whether the truck was maintained properly, whether the load was balanced correctly. That level of digging is what turns a case from guesswork into proof, finding every responsible party because it's often not just the driver. This is the step that can change the size and stability of a truck accident case. A truck crash might involve multiple layers of responsibility, such as the driver, the trucking company, a company that hired the carrier, a loading or shipping company, a maintenance contractor, a manufacturer if a component failed. Why does that matter? Because each party may have its own insurance coverage and its own duties. If you only focus on the driver, you might miss the deeper reason the crash happened, and you might cap your recovery far below what your damages truly are. I've seen cases where the driver made a mistake, but the company's policies set them up to fail. I've seen cases where a maintenance issue was the real cause. I've seen cases where poor loading turned a routine trip into a rollover. My job is to map the chain, not just blame the easiest target. Calculating the real value of your case, not just today's bills. Most people think only about the bills they can see. Ambulance, ER, imaging, prescriptions, a few missed days of work. But a serious truck crash can affect you for years. In Florida, damages can include medical expenses, lost income, reduced earning capacity, and other losses depending on the facts. And for motor vehicle cases, pain and suffering is not automatic. Florida's tort threshold statute limits when you can recover non-economic damages like pain and suffering. Under Florida Statute 627.7372, you generally may recover for pain and suffering only if the injury involves things like a significant and permanent loss of a bodily function, permanent injury within a reasonable degree of medical probability, significant and permanent scarring or disfigurement, or death. So part of my job is to make sure your medical evidence matches the legal standards and that we do not leave money on the table by underdocumenting what really happened. This is also where we bring in the right experts when needed. Medical experts to explain the injury, economists to explain future earnings loss, accident reconstructionist specialists to explain mechanics when the defense tries to rewrite the crash. A trucking insurer may offer $10,000 to make you disappear. But if your injury changes your ability to work, lift your kids, sleep through the night, or live without chronic constant pain, a real case value analysis has to account for that. Taking the fight to court and knowing Florida's 2026 deadlines. Most truck accident cases settle, but you never want to build a case like it must settle. You build your case like it will be going to a trial. Because the moment the defense realizes you are not prepared to go to court, their offer drops. Now, let's talk about deadlines, because this is where people lose cases without ever knowing they had one. Florida's statute of limitations for an action founded on negligence is 2 years. Florida's statute of limitations for wrongful death is also 2 years. These deadlines are strict. If you miss them, the court can bar your claim forever. That's why I tell people, do not wait until you feel better to call a lawyer. Your body may need time. Your case does not have unlimited time. Helping you move forward, not just to win a settlement. Here's what people don't see on TV. A good injury case is not just paperwork and court filings. It's answering your questions when you're overwhelmed. It's coordinating records and bills so you are not blindsided. It's keeping you informed so you are not living in the dark. It's pushing back when insurance companies stall or mislead. My goal is always to give you back control after something violent and unfair took it away. Because after a truck crash, you're not just trying to win money. You're trying to rebuild normal life. What you should take away from this. If you've been in a truck accident in Florida, here's what a truck accident lawyer should do for you. Get you into the appropriate medical care fast, because Florida's 14-day PIP rule is real. Protect you from insurance tactics and fault shifting, especially with Florida's modified comparative negligence rules. Preserve trucking evidence before it disappears. Identify every responsible party, not just the obvious one. Calculate the true value of your damages, including the legal threshold for pain and suffering in auto cases. File on time, because Florida's negligence and wrongful death deadlines are now 2 years in most cases. Now, there's one concept that decides the outcome of almost every injury case, whether it's a truck crash, a slip and fall, or a dog bite: negligence. If you want to understand what it really takes to prove fault and win, watch my next video, Proving Negligence in Florida Dog Bite Lawsuits. Because once you understand negligence, you stop relying on what feels fair, and you start building what actually holds up. Go watch Proving Negligence in Florida Dog Bite Lawsuits now. See you over there.